SJC-11380, Commonwealth v. Carl Sepheus.
All right, let's proceed, please. You step up in front of the microphone.
Good morning. May it please the court. My name is Leslie Powers, and I represent Mr. Carl Sepheus on this appeal before the court this morning. The issue in this case is a very fact-driven, narrow issue, and that is, was there sufficient evidence in the trial of this case to convict Mr. Sepheus of possession with intent to distribute crack cocaine?
Now, he had three pieces of crack.
Correct, sir.
And baggies.
Yes.
And he had $300 and some in his pocket.
314, that's correct.
And he was seen with a group of people in an area that was known. What was it known for?
Well, it was, if I may, Chief Justice, there was an indication that it was a quote-unquote high crime area. But I would point out to the court that the testimony of at least one of the officers is that Mr. Sepheus had a warrant. They had information that he was going to be in this general area, and he was found approximately an hour later in that area, but it wasn't it was in a generalized area. So I think it's very difficult to say that just because he was in a high crime area, that has really any weight in terms of they only observed him for no more than a minute. The police arrived, they saw a gentleman that fit his description. They observed him for about a minute, and Mr. Chief Justice, what the officer testified was Mr. Sepheus was here with a group of gentlemen. There was a separate gentleman who they observed actually conduct what they considered to be a drug transaction. It was very clear from the testimony that Mr. Sepheus did nothing, didn't wave people down, they didn't observe him waving down or doing anything to facilitate any kind of drug transaction. So I think his mere presence cannot be used to bolster the idea that he was somehow involved with this other gentleman, who in fact was arrested for the distribution charge, Mr. Griffin. Mr. Sepheus was over here with a different group who then went in. Mr. Griffin apparently went in with them to the Dairy Mart or the Valley Mart. But just his mere presence alone is not really probative of whether or not he was involved in any kind of distribution absent other evidence.
Well, he had $314 in his pocket, so what weight does that add to this case? Or 312, I can't remember.
Actually, Justice Corday, I would say very little. In the case, the Gonzalez case, which the majority opinion in the appeals court really depends on, or depended on, in that case, there was testimony that the defendant was unemployed. Mm-hmm. In this case, there was an attempt to get some of that in. It was objected to because it would be hearsay. So there was absolutely no evidence as to Mr. Sepheus's employment status. So I would say that absent either evidence as to his employment status, or even if they had gotten in some evidence of how the money was, the denominations, that would have aided the Commonwealth's case. There was no testimony of that as well. For example, I believe—
I don't know how the denominations would have aided the Commonwealth's case.
Well, if I may, they had some cases that talk about the denominations may bolster the Commonwealth's case when the police officers had testified that they were talking about 10 or 20 is the usual amount in that area for sales of crack cocaine. So if they had shown that there was money, maybe all 20s.
But if you go to an automated teller machine, that's all you get back.
I'm agreeing with you,
20s.
but I guess I'm trying to address the question of whether it helps or hurts.
Cases that suggest that the way it's held in a pocket, that it looks like it was just stuff there. So what you're really asking us to consider is whether this may be one of those. It's a close case when
Extremely.
you have just a small amount of coke distribution, a coke which could go either way,
Correct.
and some cash. You have no other indicators, cell phones, pagers, if people even use them anymore, that kind of thing of distribution.
Correct.
No conduct suggesting distribution.
Correct.
Is it enough? Does the cash do it?
And I believe it doesn't, unless you can show that the cash, again, has some sort of special magical meaning. Even, in other words, if the officers testified that the usual amount of cocaine sold, it was at $20. And so if you're saying that Mr. Sepheus was a seller, you would expect that the cash he had on him would have been in denominations such that he could either make change or he had been selling it. We have no evidence at all. We don't know if it was $300 bills.
Well, there was one other thing that
Yes.
they talked about, and that was the absence of any kind of drug paraphernalia. What do you think about that?
Quite frankly, not much. I think it was an interesting argument, but I think that the officer that testified to that was clear that, yes, I've arrested people with this amount of crack cocaine. Yes, sometimes they've had smoking material. They usually have it, but they don't always have it. And when they don't have it, I don't always charge them with possession with intent. And factually, Chief Justice, I think something that's quite interesting in this case is where they were. They were at a Valley Mart, which is a convenience store. And both officers testified that you can use a Coke can to make smoking apparatus. The first officer also testified that you can crumple it up into marijuana. And they were asked, well, do you know whether this store sold rolling papers? And they didn't know. They didn't know. But I would suggest that it's not beyond the common knowledge of the founder of fact that a convenience store would sell cans, that one could have made, if one wanted to, a smoking apparatus out of it. I would also suggest that there are a whole host of, well, let me strike that. I'll just leave it at that.
On the drug sale, I just wanted to return to that. I know you said that mere presence near someone who sold the drugs is not enough. How long a period of time did the police observe the defendant at that location?
My understanding from the transcript was approximately a minute to a minute and a half. They saw him then go into the Valley Mart, and they observed him, I believe, through the glass for another minute, but there was no indication that anything untoward happened while he was in the convenience store. But outside, it was approximately a minute to a minute and a half before backup arrived.
Now, what do we do with the elephant in the room, which is the CI information that came in initially merely to indicate why the officer was there, but then was used by the expert as part of his reason for his conclusion?
I understand, and that was unfortunate. I feel, defense counsel did an admirable job in the trial. I mean, he objected all over the place. He moved to strike. He was very clear that the CI information only came in, and the court ruled, he objected to it, but the court ruled it came in for why the police officers were at the scene. It was unfortunately on cross-examination, then the sentence came out. What did you base on your belief? And one of the things the officer said was, information we had about Mr. Sepheus. It should have been objected to, should have been stricken. It unfortunately wasn't. The question is what effect it had. Unfortunately, in this sort of very hot-housed, truncated trial, lasts about an hour and a half, I think it has an exaggerated importance. It's not like we have 2
The question,
weeks.
though, is what effect should it have on the analysis of the sufficiency of the evidence?
Well, I think, unfortunately, I think that it shouldn't have come in, and I think the court has to see if, in fact, that influenced the court. And given the paucity of direct evidence and the other factors that seem fairly weak, I would suggest that it had to have an effect, because otherwise you're really left with a very close case. And this kind of tips it over if the court used it and it came in unobjected to. So we have to assume the court considered that.
Do we take into account that this was a jury-waived trial and was an experienced judge and that he could figure out that that wasn't supposed to be there?
Of course, Your Honor. I mean, I think that's one of the things that the court will do, and I think that everyone would agree that that was the hope. However, I would suggest that trial judges are people, and it's still evidence that came in. It came in unobjected to, and we don't know if it had an effect. Unfortunately, if it had been objected to, we could talk about it was non-prejudicial only if. But we're left with a substantial miscarriage of justice, and I would say that given that it did have an effect, because the Commonwealth's case was very close and very weak, the error was of constitutional proportions because it implicated Mr. Sepheus's right to confrontation. and that there was no tactical decision for it. I think it was just, I think defense counsel unfortunately just missed the objection.
What was the money, the $314, where was it on the defendant's person? Was it in his wallet, or did he have a wallet? Was it in his front pocket?
It's interesting. It's not clear. It was found. It wasn't. He was patted down twice. Once when he was arrested, it wasn't found. Then when he's in the back of the police car, he's taken back out because they feel he's made some strange movement, and they found the coke. The money isn't found till he's patted down at the station. But it wasn't an indication. There's a case, and I'm sorry, it's escaped my mind right now, where the money was found, there were like gym shorts, and the money was secreted, and then there were pants on top of it. That doesn't seem to be this case at all. It seems that the money was found in a pocket during a straight pat-down, not indicating that it was being hidden.
Was there any evidence of the inventory of his belongings at booking?
I'm sorry,
So we
Justice
don't know if
Spinner,
he
I
had a
don't know.
wallet or not?
I don't know. I
Okay.
apologize, I don't know. There wasn't evidence at trial of that.
Going back, I guess, to the CI information.
Yes, sir.
The judge made it clear, at least earlier, that he was going to consider that only to the extent that it bore on the reason why the officer went to that location.
Yes.
Does it bear on the weight of the opinion if we assume that the judge was not going to consider it for its truth? I mean, the opinion is based in part upon the other information, which I assume is the CI information, because that's the only information that's referenced. Should that bear on our evaluation as to what weight to give to that expert opinion? If it's based in part upon information which is explicit, which we've said, the appeals court said in Tanner, is exactly the kind of information we don't want these experts to be relying upon.
Well, I believe, yes, it should be given weight. If I understand your question, Justice Gant, I think that clearly that question and that answer on cross-examination implicated Mr. Sepheus's right to confrontation, and therefore is a constitutional error. And I think it has to be, I think, because it wasn't objected to. Again, earlier, the court is very clear. I'm not going to take it for the truth of the matter. It's not hearsay. I'm only taking it for this. However, when you get to the cross-examination and the unfortunate statement is uttered, then that is a problem, because clearly the officer gets it out, and that other information, clearly based on other information from a third party, which we have no way to test, and that should come out. That shouldn't have been considered. And I think given the closeness of the facts in this case, that if you take that, I think personally that the case.
I guess the question is, should we sort of discount that, say that?
Discount the weight of
Discount the weight of the information upon which the officer made.
Well, even if you do discount it, I think if you.
If you
so
discount it, all you're left with is the money and the place
proximity and the
the
place.
3
Right.
bags.
Yes, I beg your pardon. So yes, I would say discount it. Is there anything else?
Thank
you,
you,
counsel.
counsel.
Thank you very much.
Good morning. May it please the court, Bethany Lynch, Assistant District Attorney representing the Commonwealth in this case. I will start out just first on a factual matter. Justice Spina, you asked where the money was found on the defendant. According to the testimony, it was found in his right front pants pocket. So there was no indication of a wallet, but it was found in his pocket. It wasn't secreted, as my sister said, in any kind of interior clothing. It was in his right, just his front pants pocket. As for this case, the Commonwealth's position is obviously that the evidence was sufficient. It is a close case. I will not argue that there was overwhelming evidence of sufficiency in this case. But the evidence that was presented at trial was sufficient to get to the fact finder on a motion for required finding.
So let's just assume there's an arrest warrant out for this person, and he's seen walking down the street, and he's arrested, and at the station, 3 little bags of crack are found on his person and $314 or $312. Is that enough?
By itself, no. No.
So what's the additional thing?
I would say that there are several additional things. I would argue that the location where he was found, I would say, is a factor. None of these factors in a vacuum would be enough. I would acknowledge that. But taken as in total, looking at the complete picture, the fact that he was found in a location that the officers testified was known for narcotics and for guns as well, but it was known for narcotics sales, this area where he was found.
Well, you would
He
think
was
that
found-
someone would go to a place known for narcotic sales to buy narcotics.
Absolutely, absolutely. But you take that and the fact that he was at this convenience store for a period of time longer than it would have taken him to purchase narcotics.
Well, you say
He-
that,
he
but
would-
that's.
But I mean, but he was there for a minute
Judge Traynor
or
relied
two.
upon that, but there is no evidence, apart from the CI information, that said that he was there for more than, they only saw him for 2 minutes.
But I would argue that 2 minutes is a period of time that he had already, theoretically, he would have already completed his purchase if he were the buyer. Why would he stay for another 2 minutes with 3 or 4 people, one of whom was dealing drugs? He stayed with these people for a period of time and then accompanied them into the store. So I would argue that he wasn't just a buyer going to a location to buy his drugs and then leave to ingest them. He was with this group for a period of, granted, it was only a minute or two, but a couple of minutes when a transaction occurred and finished within that minute that the officers with another individual. So a transaction, the evidence would show, is a very quick thing.
But the expert didn't testify to that, did he?
No, but I would say that you can infer that from the
Was to infer that based on our own knowledge of how
No,
users
based on
behave?
the fact that he wouldn't stick around, or the fact that, I mean, I think that there was evidence that a drug transaction in that parking lot was very quick because one occurred in that minute and a half. And the buyer came, bought the drugs, and left within that period of time.
But there could be innocent explanations
Absolutely.
for him to be there for a few minutes as
Sure,
well.
yes, but there can, if you pull them all apart, every individual piece, you can come up with an innocent explanation for. But based on the
So what else besides
totality-
that one? What else?
Besides that, then you also do have the absence of smoking apparatus. The officer testified that he has in the past arrested people with a small amount without the smoking apparatus, but that it was very rare. And so based on that, he offers the opinion that in the absence of that, the individual was more likely selling than buying drugs.
But this guy didn't have on him either things that you would expect a seller to have other than cash. I mean, you say that there's no
Yes.
smoking apparatus, there's no selling apparatus either.
No, no, there's no direct selling apparatus if you define selling apparatus as weights and logs and pagers and cell phones.
Even a cell phone, he didn't have anything like that.
There's no evidence that he had
He didn't.
had anything.
There's
like
no
that.
evidence of a cell phone.
There's no evidence of a cell phone. There was no inventory of what he had on him at the time of his arrest.
Chris, I
But-
take it, what your approach to that, or your response to that, is essentially, look, this was an open bazaar.
Well,
You-
yes.
People that are selling hot chilies or something like that at an open market, they don't have pagers or any of that kind of stuff.
Yes,
The
this-
customers
this-
come.
Right, he would have been there just with the drugs and the money. That's how he would have been engaging in the transactions. So he wouldn't necessarily have these other things, and I don't think that the absence of the other things is fatal. The absence of the smoking apparatus, in conjunction with the expert's testimony that the absence of smoking apparatus to him, as an expert narcotics investigator, indicates that it's more likely that he was there as a seller than as a buyer, because it was rare not to find a buyer of a small amount of crack cocaine to not have a smoking apparatus in his or her possession when arrested.
Was there any evidence as to what the other person who was there selling
Yes,
was arrested?
yes, he was.
Was there any evidence that came in about what he had on him?
No.
or-
No, there wasn't. And this also was not a joint venture case. So in terms of waving people over or anything, the defendant wasn't charged with that distribution.
No,
So
but I
the
mean,
his
it's
mere
just-
presence doesn't go to that.
I guess my question really went more toward, all of this is also consistent with him being a buyer, including from that seller.
Yeah, oh, I would not agree that it would be equally consistent, but that he could, theoretically, of course, he could have gone and bought from him.
But there's no evidence
But
that the
there's-
packaging of what it was.
That he was
that
selling,
Griffin
no.
had,
No, there was no evidence as to the other defendant.
Ms. Powers suggested, maybe I misheard her or misunderstood her, that actually this defendant, at least before going into the store, was not part of the group from which the seller, Mr. Griffin was part of.
My reading of the record was that the group was together and that Mr. Griffith left, kind of walked away from the group to conduct the transaction and then kind of came back to the group. I mean, I don't know that they were standing like directly together, but they were all in the same area of the gas pumps outside the store. And Mr. Griffith walked away from this group of people, conducted the drug transaction, and then walked back towards the group of people, and then the group together went inside the store. So I think from that evidence, it's reasonable to conclude that the defendant was at least somehow affiliated with this group. He wasn't a stranger to them. He was with them while they were conducting drug transactions. He was going with them into the store. He didn't go his own separate way then. He didn't go into the store separate from them. He went in together. As for the issue of the hearsay statement in the testimony, in the officer's expert opinion, the fact that there may have been one improper basis for his opinion should not taint his entire expert opinion.
But should we discount it?
If you do, it would go to the weight of the expert opinion, which wouldn't go to the sufficiency of the expert opinion in the light most favorable to the Commonwealth would still have its full effect in terms of sufficiency analysis.
But what do we do with the fact that the expert said, in answer to the question, and so you're relying predominantly on information that was provided by outside sources? He answered yes, from a reliable informant, correct.
He did say that, but I would also argue that he had listed out an entire laundry list of bases for his expert opinion or foundational supports, and that this one line, our information about Mr. Sepheus, was nonspecific. There was no, what that information is was never explored here, and that it followed the question, did you personally see Mr. Sepheus engage in narcotics transactions? And he said no, because he didn't, a fellow officer did. And the question is, you were predominantly relying on information provided from outside sources. I'm not sure that the answer is, I'm not sure that that answer is that yes, he was relying exclusively on the information that they received from the CI that got them to the scene. It's clearly one of the factors that he lists in basing his expert opinion.
And can we consider that? I mean, I thought that one of the concerns about having police officers as experts, and the reason why you generally would have somebody who has nothing to do with the case serve as an expert, is precisely the fear that information not known to the jury but known to the officer may be affecting his opinion. So isn't this exactly the fear that we have as to the caution to be used with regard to expert opinions by police officers?
It is, and I would agree that this statement should not have been included. But the fact that it was only one of numerous bases for his opinion, if you excised it out, there was still sufficient foundation for his opinion, the opinion that the rocks and that the situation was more consistent with a possession with intent to distribute than a straight possession case should still stand. That the fact that he bases it on the packaging, the excuse me, the amount of money in his pocket, the absence, the location, the group and the situation that was observed by the police, and the absence of smoking paraphernalia, all of those things together, as well as information that he had, combined to make his to create his expert opinion or to support his expert opinion.
You know, we keep on hearing cases where police officers make these gratuitous statements, and I'm curious. First, how many years' experience did this officer have on the?
I believe I'm not sure the number of years
it
off
at
the
least
top of my
10?
head. Oh, I would assume that I do have a note that he had over 2,000 arrests in narcotics. I believe he was 9
and
years
he
in
testified
narcotics.
many times. And he'd been on,
And there was no challenge to his
as a
status.
prophylactic measure, why shouldn't we essentially discount everything that this officer said as an expert. And he's not an expert. If he can make a statement like that, it's outrageous, isn't it? You say it shouldn't have come in. Of course it shouldn't have come in. What can we do to prevent this from happening? Because it comes up all the time.
So not allow expert testimony?
Not allow an expert to slip in these kinds of statements. Why does that keep happening?
That I cannot answer. I'm sorry.
Did anybody chastise this officer afterwards for making the statement?
No, it was never referred to. It wasn't objected to. The defendant didn't bring it up. The judge never mentioned it.
Of course, it wasn't
was
objected
one
to,
line.
but it shouldn't have come in, period. I'm assuming that they know better than to make these kinds of statements, these experts.
I believe, I would assume so. He's an experienced police officer. But he was also, it was also in cross-examination, and the defense attorney was using this as to keep going back to the outside sources. The defense attorney was also using this as a challenge to his credibility on cross-examination, where he was, he brought it, I mean, he was, but poking at the foundation of his expert opinion, and he had the officer list out his reasons. And this officer did say our information about Mr. Sepheus. In the context, I would agree that our information is likely referring back to something he knew from a CI, but the actual CI's information was not before the judge.
You know,
He had
if-
previously excluded
If I
that.
could just follow up on one aspect you've talked about, and that's the location. I'm just wondering if that puts all of the people who live in that location at a disadvantage. Are they all assumed to be engaged in selling drugs?
No, of course not, Your Honor.
So some might be purchasers, but they're going to be
And that's why it is but one factor. And it's something that I don't think the court should just toss aside. It's something that the court looks at. But if you were there with smoking paraphernalia, with very little money, with a couple of rocks in your pocket, in a high crime area in a place known for narcotics, that would be a purchaser. But in this case, that's not what we had. We had a high crime area known for narcotics with a man with rocks of crack cocaine, with over $300, without any visible means to ingest the crack cocaine, in the company of people who were actively selling crack cocaine.
What if he left his equipment at home and said, I'm going to go and...
Theoretically, that's possible, but in the assessment that we're making here is whether the evidence as it was in the light, excuse me, in the light most favorable to the Commonwealth would have been sufficient to get the case to the jury. And in the light most favorable to the Commonwealth, the officer testified that the absence of smoking paraphernalia was a significant factor in his expert opinion.
Hear that a lot, and I'm just realizing I don't have a clue whether it is in fact common, and an expert like this would know, that the people who use crack cocaine like to have the paraphernalia to use it because they're going to stand right there in the middle of the street where they can be seen and smoke it. Or do they go home or some other place where they're not visible, where they can do what they do to do it? I have no idea. And was that part of the expert testimony?
Not the
It wasn't.
entire assessment that you're saying. What the officer testified to is
Conclusion
that
that
in his experience, he's had over 2,000 arrests, and in those arrests, when he arrests people that are users, it is very rare not to have them with their paraphernalia right on their person. They likely won't smoke in the parking lot, but they could just as easily go around behind the building. I mean, they usually have it with them because they're addicts and they want to smoke right away. And he offered that opinion.
Well, he didn't say rare. He said they usually have something on their person.
Perhaps it was rare that they don't.
I don't remember
No,
seeing that.
I'm sorry.
Again,
I'll defer to the court and to the
I
record on
remember,
that.
he certainly said they usually have something on their person to ingest the drug, but I don't remember him saying it's very rare, maybe on cross.
Can I ask you a question that just, I've never really understood, particularly when you're talking about small amounts of drugs, why packaging makes a difference one way or the other? Because whether you buy it or you sell it, it's in the same package.
That's true. That is true. But Again, it's one factor. The fact that
But I
they
mean,
were
that it's
all-
packaged, I see, I just don't understand it. I mean, is
Well,
nothing,
it
something
was
unique
packaged
about
in
the
the same-
packaging? Does it have his name on it? I mean, it just,
No, it was packaged and tied off in the same way. It
well,
was
okay,
in the
but
corner
you'd get
with the
that if
knot
you
in the
bought it,
center.
and you'd have it if you sell it. So I don't understand why any of these are the problems with some of these factors.
Mm-hmm.
They don't really, you say, well, okay, it was standing alone, that wouldn't do it, and standing
Right.
alone, that wouldn't do it. That's because standing alone, it doesn't cut one way or the other.
Right.
It's
I
just sort
understand.
of, 0 plus 0 plus 0 plus 0 sometimes magically becomes 1, and I don't understand that.
Well, I would say that the fact that the materials, the fact that it was packaged in a similar manner, in addition to the money, those two things together, and the absence, together, I would argue that there's a reasonable inference that he was just low on inventory as opposed to he had just bought this.
Counsel, we're going to have to leave it there.
Thank you.
Thank you.
Thank you, Your Honors.